All right. Good morning, everybody.
Good morning.
Looks like everybody's is hooked up who wants to be hooked up. I'll just advise Ms. Horning and Mr. Kim, I see your tiles, but I do not have any videos of you. Now I have a video of Mr. Kim. Good morning, Mr. Kim. And now I have a video of Ms. Horning. Good morning, Ms. Horning. So let's go ahead and get started. My name is Alan Lilly. I'm the presiding hearing officer of the State Water Resources Control Board's Administrative Hearings Office. Today is May 25, 2022, and it's just after 10 a.m. This is the pre-hearing conference that the Administrative Hearings Office is conducting in the court's reference to the State Water Resources Control Board in City of Marina versus RMC Lonestar, Monterey County Superior Court, number 20 CV 001387. And I apologize for having to delay the start of this pre-hearing conference from 9 o'clock until 10 o'clock. I had something else come up and appreciate your accommodation of that. At least nobody was appearing in person, so hopefully you were able to occupy yourselves with other activities during the intervening hour. As stated in section 12, on page 21 of our May 6, 2022 Notice of Public Hearing and Pre-Hearing Conference, the AHO, and that's what I'll use as shorthand for the Administrative Hearings Office, will be adding the Zoom audio plus video recording of this pre-hearing conference to the administrative record folder that the AHO is assembling for this matter. And the AHO has not ordered a court reporter for this conference. I'm checking here. I do not see what appears to be any entry of appearance by any court reporter. Is there any court reporter here today? Okay, seeing none, I'll just advise you the official, it would be anyway the case, but our Zoom audio plus video recording is what we treat as the official record of this pre-hearing conference. Zoom also generates I will say, rough transcript of the audio part. It's probably about 90% accurate. It's not quality controlled by anyone. It's just computer generated. So you can use that for reference, particularly if you want to find a particular hour, minute, and section where something is discussed. It's pretty good for that, but it's certainly not our official transcript, and it's not 100% accurate. All right. So with that, I'm going to ask the different parties to have the attorneys for the various parties to enter their appearances, and we'll get started. Who is appearing today for City of Marina?
Good morning, Mr. Lilly. Skip Spalding for Marina.
All right. Good morning, Mr. Spalding.
And good morning, Mr. Lilly. Larissa Meisenheimer also be here on behalf of the City of Marina.
All right. Good morning, Ms. Meisenheimer. Anybody else for City of Marina this morning? All right. So who is appearing today for Marina Coast Water District, which I will probably refer to as Marina Coast for short.
Good morning, Mr. Lilly. Kyle Brochard on behalf of the Marina Coast Water District. Also on the Zoom is Jim Markman, Tilden Kim, Ruth Stoner Muzine, and Chip Wilkins.
Okay. Good morning, Ms. Brochard. Mr. Brochard. Is it Brochard or Brochard?
The second one.
Brochard. Okay. Remind me. I will try to get it right. I'm bad with name pronunciations, but good morning, and good morning to all the rest of you. All right. And then who is appearing today for California American Water Company, which I, like everyone else, will refer to as CalAm?
Good morning, Mr. Lilly. This is Bob Moore, Alan Matkins, and I represent California American Water, along with others.
All right. Who else is here for CalAm?
David
Osias, Your Honor, also from Alan Matkins.
Okay.
Morning, Mr. Lilly. Michael Betts, also on behalf of CalAm from Alan Matkins.
All right. Thank you.
Robert, excuse me, Mr. Lilly. Robert Donlan, Ellison Schneider for CalAm. Good morning, Catherine Horning with CalAm.
All right. And good morning to all of you. All right. And then who is appearing today for RMC Pacific Materials LLC, doing business as CEMEX, which I will probably refer to as RMC Pacific.
I am Mr. Lilly, James Newdecker from Jeffer, Mangles, Butler, and Mitchell.
Good morning, Mr. Newdecker. And is it okay if I refer to your client as RMC Pacific?
Yes.
Thank you. And then we have previously had an appearance from the Salinas Valley Basin Groundwater Sustainability Agency. I don't see anybody from them today. So I'll just ask, is there anyone else who wants to participate in today's pre-hearing conference on behalf of any other party? All right. Well, we certainly have a very distinguished group of attorneys, and I'll look forward to working with you in this matter. So I issued a notice of public hearing and pre-hearing conference on May 6th, which I assume all of you have received. And before we open it up to discussion, there are several points and a couple of questions I have regarding this notice. So I'm going to flip through it. I hope you all have it either the old-fashioned way in paper, the way I do, or electronically. And I'm going to just go through that. And where I want to start is on page 3. And this is something I've meant to ask all of you before. And I didn't really have any way to do it outside of a proceeding like this where everyone was present. So I now have made a note to ask. And I want to ask how, and any of you who wants to can volunteer to answer, the court obviously specified these 8 issues that it referred to the State Water Board for these proceedings, and then the Water Board's executive director assigned to my office. And I'm just wondering, how did the court develop these issues? And in particular, what input did the parties have as the court developed these issues? So, and this is really more out of just curiosity. I'm not sure it affects how I'm going to proceed. I mean, obviously, we will try to address and respond to these issues as the court has specified them, but I'm just sort of curious as a matter of background. So can anybody volunteer some information about how the court ended up developing or specifying these issues? Mr. Markman, you're shaking your head no. Does that mean you don't know? You always know. What's the answer? But go off mute first. Still on mute. We can't hear you. Still can't hear you. I don't know what happened.
Got it.
Now we can hear you.
Thank you. So I think a lot of them followed sequentially through our pleadings and the responses to our pleadings. They're pretty detailed pleadings and answers. And I think that they follow in the same kind of, we hoped, logical way we proceeded to get to the end. And believe me, no one from our group conferred with the court in any way. Never came up during a hearing. The list of questions simply appeared, but it appeared after the pleading stage was completed.
Okay. Well, that's helpful for me to know. So it wasn't, I take it then, it sounds like you're pretty clear. No, the parties did not submit proposed issues or anything to the court before the court issued this order.
That's correct. We did not.
And also, it sounds like the court didn't circulate draft issues. The court just issued the order. Is that correct?
Yes, that's correct.
Okay.
Mr. Lilly, a little backdrop, and you may know that is we made the motion for a reference, that being CalAm.
Okay.
It was significantly opposed by the city and the Marina Coast Water District. Replies were followed. And then the hearing took place in which the court came up with these answers or questions.
Okay.
And
Okay. Well,
And-
that's help. I guess that's helpful. It's just so you know, one thing I am not going to do is have any ex parte communications with the judge. I don't think that would be appropriate. Although if the judge calls me, that will be interesting. I certainly, I tend to follow court's orders, but I just was wondering by way of background, I don't think the court will call. I think the court has issued its order and expects me to proceed. But anyway, I just was sort of curious as to where they came from. So that's helpful. Any other comments on that? My question? Go ahead, Mr. Asias.
Yes, just to confirm, in the motion, opposition, and then reply papers, each side took clearly differing views on whether any issues should go to the state board and what they would be.
Right.
And, for no issues, the list was rather short. And for what they should be were in our papers, but no proposed order and no list that looked like this list was submitted to the court. This was created out of whole cloth by the judge after review of all the papers and a hearing. And my memory is not perfect. It might have even been 2 hearings where he asked a variety of questions and then said he would issue an order. So he didn't rule from the bench first either.
Okay. Thank you. And I think we have a folder in our initial administrative record about documents filed in court. And I think we have the motion papers for the reference in there. I know I've read them, and nowhere else I could have found them. So that is helpful. So thank you again. It's, as I say, more curiosity on my part than anything that will necessarily affect how we go forward. So I do want to move forward through the notice. On page 5, I listed several pre-hearing conference issues, and I'm going to circle back to those as far as things like schedule and time limits. We need to talk about them, but I want to first proceed with some other discussions, and then I will ask for your input on that. And I did receive the joint pre-hearing conference statement from City of Marina and Marina Coast Water District, which addressed some of these issues. So, and thank you for that. So I will circle back to those. So moving forward to page 7 of the May 6th, my May 6th notice, I just wanted to sort of summarize or reiterate. I developed this schedule. We did have, I think, 2 previous status conferences, and I developed this schedule. It became pretty clear, and I know you didn't all agree with exactly these dates or this process, but it became pretty clear to me that if I set deadlines for written proposed direct testimony and associated exhibits and exhibit identification indices, and then we have about 5 or 6 weeks later a deadline for written proposed rebuttal testimony, associated exhibits, and exhibit identification indices, I think we can get out pretty clearly what the witnesses plan to talk about. This is in lieu of expert witness reports, which are provided for in the Code of Civil Procedure for civil court proceedings. I think this, if anything, will provide quite a bit more detail than those reports, because this really is what people are going to testify to. But anyway, that was my plan. And then to have a time for, if any of you want to take depositions of any of the designated witnesses before the hearing starts. So that was my thought process for going ahead and setting the schedule that way. And I know there's some questions about schedule, so we'll circle back to those, but there are a couple of other points I want to emphasize first. So on page 10 of the hearing notice, I do have several paragraphs about ex parte communications, and you're all experienced attorneys and know about ex parte communications. And I think you can appreciate why I want to prohibit ex parte communications. I know it's a little bit of a pain sometimes when you're trying to upload a file and there's some glitch, and sometimes there are problems at our end on that. But again, we have email, it works pretty darn well. And then you can just include everyone else on the CC line, and you may say, well, I don't think anybody else really cares about this, but frankly, even if it's figuring out how to upload a file, somebody else may be having a similar problem, so they may appreciate the CC. So anyway, that's the way I want to do this. I know it's far more rigorous than other administrative agencies and even courts normally do that, but this has been my experience after decades of working in water board, water right proceedings. I think this is the best way to go forward. One thing I did want to say, I think it's listed in here. We will continue to update our service list for this matter, and we have posted a Word file. Everything else we post, I think, is PDF, but we have a Word file of the service list, and it's in a separate folder called Service List, which you can download from the AHO FTP folder for this proceeding. And the best thing to do is whenever you're sending anything out that requires a proof of service, is just download that up-to-date Word file of the service list and paste that into your document at the end. That way you'll make sure you have the most up-to-date service list. And I've asked my staff to do that as well. We probably won't have a lot of changes to the service list, but in case we do, that should work. I did receive a bounce back yesterday in reply to my email advising about the change in the start time, which said it was undeliverable. And it was something from SF Law. It says postmaster at SF Law LLP and then on Microsoft.com. So, and I did check the service list and SF Law LLP. I'm trying to remember. I know that's one of your law firms.
That would be our law firm.
Okay. Did all of you receive the email I sent yesterday?
We did.
I know that I did. We can confirm with each of the team members. Does it indicate which address was undeliverable?
It does not.
Okay, we'll check internally.
So, Ms. Meisenheimer, I think the simplest thing to do is after this pre-hearing conference, download our Word file of the service list and check the email addresses that are listed there, particularly the ones for the members of your firm. And then if you think there need to be any updates, just send us an email and of course CC everybody else, and we'll update the service list. And you know, I mean, it's so easy for us to add email addresses to the service list. Some people like to have their assistants included just so that they get the things, and we're willing to do that. It's just one more address on an email service list. So for all of you, let us know if you want us to add any email addresses to the service list. We will do that. Okay, thank you.
Yeah, we'll do that. Thank you.
Certainly important for everyone to get everything that we send out and that everyone else files. Okay, according to Mr. Waldridge, it's rreby at sflaw.com. I don't know, do you know, Ms. Meisenheimer, you know through who rreby is? You have to go off mute though.
Thank you. That's actually an associate who has left our office in the last few weeks, and so we'll need to remove him from the service list.
That's probably why we got to bounce back. All right, so Mr. Waldridge, if you can make a note, we'll remove rreby from our service list as well. Thank you. And you know, and as I say, things like this happen. So when they do, just let us know and we'll keep updating. We also maintain a separate email list of just the email addresses, and we'll update that too. All right. I do want to move to, and this is a more detailed discussion. I want to move to on page 13 of the hearing notice in section 6, which starts just below the middle of the page and carries on to the following page. I know some of you have had some experience with state water board proceedings, but I suspect almost all or all of you are much more familiar with court proceedings than state water board water right hearing proceedings. And there are some differences, and I want to really emphasize those differences because they're very, very important for our proceeding. the main thing is, and I have mentioned this before, but I really want to emphasize this. We require witnesses to prepare and file their written proposed testimony, both for direct and rebuttal, before the hearing. I am not aware, I never, in my years of practicing in court, I never saw a court do that. But we do it for a variety of reasons, which I'm going to mention. And I just want to emphasize, so it's really different from when you're in court where, the judge probably doesn't know who the witness is or what he or she is going to testify to until he or she starts testifying. We do this for a variety of reasons. Number one, I think it really helps the witnesses. It allows them to organize and polish their testimony to a degree that they really can't do, or nobody can do with oral testimony. I mean, unless you just start reading something, and that's kind of hard for me to absorb. So the first reason is it allows your witnesses to take time to really refine and polish their testimony and get every word exactly the way they want them. Secondly, it allows me and my staff to read it all ahead of time. And trust me, we do. And we don't just read it once, we read it and reread it and reread it. And certainly after the hearing, when we're preparing our proposed order, we read it. And a well-organized written proposed testimony document is a lot easier for us to process than a reporter's transcript, if there is one, or a Zoom video plus audio recording, if there is one. So it's really in your interest to get that polished, because it's going to, I will assure you, we use that in our decision-making process. I cannot think of a time, I've been doing this now for almost 3 years in my present job. I cannot think of a time when I've cited to a recording of a witness's direct testimony. Instead, where of course there are many, many times I cite to their written proposed direct testimony. But that's it. So the summaries, I mean, I understand there's a purpose for the summaries, but it doesn't really have a big impact on our decision-making process. I think you should look at summaries as an opportunity to hit the key points. It's like, Mr. Lilly, this is really important. I want you to really focus on this paragraph in my testimony, and here's why, that sort of thing. The third reason for this is it allows the other parties and informs them on what the witnesses are going to testify to. And it really allows for much more focused, much more efficient cross-examination. In my experience, both when I was an attorney advocating on behalf of clients and since then as a hearing officer, with this written proposed testimony submitted ahead of time, I'll ask my staff to post it, on our screen share and go to the paragraph, and then I will read the sentence or two that I have a question about, ask the witness whether he or she sees that text, and then ask a specific question. And that just really allows me to hone in on my question. I usually have a lot of questions, but I think it really helps the witness too. It's not sort of an abstract of, well, earlier this morning you testified to, and of course then the witness says, well, that's not exactly what I said, or I don't remember saying that, or something like that. In this case, it's, okay, here's your written testimony, here's my question. So think about that as well when you're working with your witnesses. I know they write their written proposed testimony, but when you work with them on that, think about those considerations. And it also, of course, saves a lot of time for all of us to do that. Now, many of these benefits would be lost if witnesses deviate from their written proposed testimony when they're supposedly summarizing it. And this happens. And I think what happens is people write it all out and then they think of more things, and then they get ready for the hearing, and the night before they think, oh yeah, I've got to make these 5 additional points. And then of course the attorney for the other side objects and says that's not in his proposed testimony, you shouldn't allow it. So it's a long way of saying, even though this hearing doesn't start till middle of October, really work with your witnesses, please, to make sure that their written proposed testimony, direct and rebuttal, is polished. And then tell them to go on vacation and don't think about it. But I'm joking, of course, but I'm going to be pretty hard or pretty stringent if witnesses come in and say, hey, I thought of 3 more points I want to make that aren't in my written proposed testimony, particularly where we have a round of rebuttal. So I said it before, I'm saying it now, and I really mean it. I think I probably will be pretty harsh on that because I know you're all competent and experienced attorneys who can follow these requirements. So having said that, let's go forward to the summaries. The summaries should really just emphasize the key points. Trust me, I will have read everything, not maybe every single 1,000-page report, but I will have read every written proposed testimony document that is submitted for this hearing before the hearing starts. My staff will have read them. We will have conferred about them. So we are going to be prepared. So you don't need to summarize, you don't need the summary to repeat everything on the fear that we haven't read it. So anyway, please do that so it really is just a summary rather than more detailed testimony. And that's why the summary slides are important because I think they really are good props that help remind the witnesses of the points that they want to make and let them make it. And I will come back. I know some of you suggested we have a later deadline for the summary slides, and I think that may make sense here. So an additional fairly minor point, although it's important, at the top of page 14, it says each party shall designate each of its witnesses' written proposed testimony as a separate exhibit. And people who don't appear before us, including me, the very first time I appeared before the board in a water right hearing, didn't get that. It's like, it doesn't really make any sense. Testimony is not an exhibit. A court would never mark testimony as an exhibit, but we do. And we do this just so we can keep track of them, those documents for our administrative record and to cite to them and so forth. So your first witness exhibit will be CalAm 1 or MCWD 1 or City of Marina 1, et cetera, and going forward. And that's the way we do it. It's not meaning anything more than that's the way we label the written proposed testimony so we can refer to it in the record. And the same for the summary slides, separate exhibit numbers, but give them exhibit numbers as well. I like it. We don't require pleading paper for exhibits, primarily because we have a lot of parties who don't have attorneys and sophisticated law offices working with them. But the numbered pleading paper with the row numbers down the left side really does help for referring the witness to certain line numbers. I mean, all know the drill on that. And if you can, try to make sure the text lines up with the numbers. A lot of times it ends up being halfway between 2 numbers, and that's confusing. So again, take some time on that, please, and do it that way if you can. As far as numbering, we do have formatting and numbering discussed on pages 14 through 16 of our hearing notice. And I think that's fairly clear. I prefer that you don't skip any numbers. Sometimes people do for whatever reasons. It's just sort of confusing. So I don't know whether I've lost an exhibit or what happened to the party's exhibit 25 when the list goes from 24 to 26. So if you can, try not to leave out any numbers. And for your rebuttal, you can just start with some people like to start with a new numbering sequence, like if they've gone 1 through 57, they'll start with 100. And that's okay if you want to for rebuttal, or you can just start with 58 and keep going. But again, don't have any gaps in the rebuttal exhibit numberings as well. And then finally, on that, it works best for me if you have the exhibits that have the witnesses' proposed testimony be the first ones, be exhibits 1 through 5, and then their summaries be 6 through 9. Or if you want, have witness 1, exhibit 1, and summary be exhibit 2, and witness 2 be exhibit 3, and summary be exhibit 4. I mean, let's face it, those are the ones I'm going to read first. So if they're at the top of the exhibit pile, that's good. And then they, of course, can reference the other and should reference the other exhibits that are being submitted, because that's the way to authenticate the other exhibits. But it's just my preference, a little easier to follow if you have those at the beginning. Both the written proposed testimony and the summaries at the beginning of your exhibit numberings. We do discuss on pages 16 through 18 of the hearing notice, the AHO FTP download folders and the parties upload folders. This is the system we have developed. It seems to work best for filing exhibits. If you upload them, you don't have to wait until 15 minutes before the deadline. You can do it the day before or 2 days before. You don't have to worry about any other party being able to see them before the deadline, because we won't move them over to the download folder until after the deadline. So if you don't want to miss deadlines, and it's good not to miss deadlines, you can go ahead and file them ahead of time. We do ask that you send us paper copies, just our office. You don't have to serve paper copies on anybody else, of any exhibits that are less than 100 pages long. If they're more than 100 pages long, you don't have to submit paper copies, but please put in your exhibit identification index, something like greater than 100 pages or something, so I'll know why there's no paper copy of that in my pile of paper copies. But I do like to use the paper copies. I'm still of a different generation, or an older generation, and I mark them up and flip through them and read them. Our official record is our electronic files. We don't have any paper files that we keep for our official administrator record or for archive, but during the hearing, they are useful for me, so please do that. All right, order of proceeding is discussed on page 19 of the hearing notice. My plan is to have interested parties present non-evidentiary policy statements. Sometimes there are others besides the 4 parties we have to this hearing who for various reasons want to say something, and I follow the board's normal practice of giving those people opportunities to make those statements. They can either file them in writing and either present or don't present oral summaries, or they can make oral statements. I limit the oral statements and the oral summaries to 5 minutes. They're non-evidentiary, but it does serve an important function for the water board's decision-making process, just to give people an opportunity to hear those. So that's the way we do that. My plan for cases in chief, since this is Cal-Am's project, my plan was to have Cal-Am present its case in chief first, and then RMC, which my understanding is it's the property owner of the property where the facilities, the Cal-Am project facilities, would be located, and then have Marina Coast Water District go, and then have City of Marina. Before I go on, does anybody have any comments on that proposed order for the parties presenting their cases in chief? All right, hearing none. And again, that's in October. We can certainly change it if we have to, but that's my plan. So obviously each party will present its case in chief with having its witnesses take the oath, affirm that their exhibits their testimony, and then being subject to cross-examination, questions from me, redirect, and then that party can offer its exhibits into evidence. And incidentally, just to save you some time, I'm not sure how it's happened, but a lot of people submit declarations for their witnesses' proposed testimony and have the witness sign it, and you don't need to do that. As far as I'm concerned, the witness authenticates his or her written proposed testimony when he or she takes the oath. And then usually my first question before I turn it over for the summary questions is Exhibit 3 your testimony for this hearing? And since the person has already taken the oath and they say that, at that point, the testimony has become authenticated and it's under oath. So if it saves you some logistical challenges, you don't have to have them sign it or do declarations. All right. As I say, then we'll, as the hearing notice says, we then will go through the same process for rebuttal. I think we'd have the parties go in the same order. So I'm going to get to time limits, page limits, hearing briefs, but I'll pause here for a minute. I've been talking for half an hour now. Does anybody have any comments on this proposed order of proceeding, just mainly the order of the parties proceeding, or anything related to that? I guess maybe I just asked that. Okay, so hearing none, I'll keep going.
Mr. Lilly,
So-
this is Michael Betts. Just briefly.
Okay,
I'm
go
not
ahead,
sure-
Mr. Betts, excuse me.
I apologize. I'm not sure we need to address this right now, but in terms of who goes first and the like, that might be something to address later. One of my colleagues may stop me shortly, but you'll see a theme of ours is this is some of these questions we believe have been answered in the past. This case, it's a redo. It emanates from a state case where the city and Marina Coast are the plaintiff. The burden rests with them. So how that affects this proceeding, I'm not sure. If I could just put a footnote there, and I think you said we could address this later, but I emphasize that we may address that issue later. So to all,
Okay.
I'm sorry if I stepped in, but I'd like
No,
to-
not at all. That's what this is for. Thank you. I appreciate your comments. And I think the time we might want to revisit this, if at all, is after all the written proposed testimony and rebuttal testimony has been submitted. And I have not set any other pre-hearing conference, but if after everything's been submitted, and maybe after you've taken your depositions, if you decide you're still going to, if anybody thinks we need a pre-hearing conference just to discuss order of proceeding or some things like that, let me know and we can set one. It would probably be in early October, shortly before the hearing starts. And we also may want to talk about time limits for summaries of witnesses' written proposed testimony at that point. So thank you, Mr. Betts.
appreciate your hearing.
Mr. Lilly, I've got one thing to add to what Michael said, and that is we have a number of different questions about evidence coming in. And I guess my request is we set a date for all the parties to, if they have an objection to a witness, if they have an objection to the testimony, and this all should be, of course, after the statements come in. But I think we should have a hearing because we have a lot of things that we want to bring to your attention. And I don't think we can wait right up until the hearing begins to do that.
All right. Certainly the time to do that is after the parties have submitted their written proposed testimony.
Yes.
I agree with you on that. This is in effect, to use a trial court analogy, you're saying you may want to file motions in limine, I think.
That's correct, exactly.
And to have me rule on them ahead of time. Does anybody else have any comments on that question? And of course, there's no way to know for sure how that's going to play out until we see what's filed.
That's right.
So what I'll do, go ahead, Mr. Wilkins, go ahead.
I think we did have a question, as Cal-Am has designated a legal expert on question 8. And I think we want to put a footnote in. I don't know if now's the time to question it, but rather than having us go through rebuttal testimony, we wanted to talk about the appropriateness of a legal expert and whether we needed to brief that issue. So we can address that later, but in terms of motions and limiting, I don't think we want to go through the whole rebuttal expert phase if you don't believe a legal expert is appropriate to answer question 8, which is, does the water board have an opinion? So I don't know if others want to address that now or you'd like to hold off on that.
Okay, I see Cal-Am's notice of intent to appear. I assume, Mr. Wilkins, you're referring to Dave Owen, who's listed for hearing issue 8? That's
correct, Alan, Mr. Lilly.
And is Mr. Owen an attorney?
Yes, he is.
Okay. That is, yeah, I don't think I can just say right off the top of my head about that. I've had this issue come up in other hearings. I'm going to go on a little bit of a sidetrack here, but what happens often is when we have enforcement matters, water board staff engineers who've worked, for many years in water right enforcement matters will be asked to testify as to some legal issues. And they're not lawyers, but they have some specialized expertise based on their years of experience. And I normally allow that just along the lines of they're allowed to apply their engineering expertise to answer a question that may have legal elements to it. Of course, that's not going to be a definitive statement of what the law will be. On the other hand, if a lawyer is just testifying as to what I will call legal arguments or legal conclusions based on precedents, and even applying the facts of our matter, our proceeding, or applying those precedents to the facts of our proceeding, that normally is something that the parties should address in their closing briefs. I mean, that's what briefs are for. Attorneys can make arguments, and they're all very good at that. And then I process them and try to figure out what to do. But it doesn't normally make sense for a lawyer to testify. You know, I testify under penalty of perjury that this is what I think the law is. I mean, you all know how that works. We all have opinions on legal issues. That's what lawyers do. But it's not testimony that supports findings of fact. So I don't know if that helps at all. Does anybody from Cal-Am want to respond to Mr. Wilkins' comment regarding the designation of Mr. Owen, based on considering what I just said?
Either Mr. Moore or I. I'm waiting to
Yeah,
see who wants to
I'm
go
looking for
first.
you, Mr. Osias, or Mr. Moore. Go ahead.
Was Mr. Moore deferring to me?
Yes, I was.
Thank
Yes.
So
You're on the spot, Mr. Osias. Give us your answer.
I am on the spot, and my answer starts with the answer I gave earlier, which is we have a court proceeding in which we have counsel who are advocates for their clients, who are ultimately going to argue before the judge about what the law means too. And he nonetheless asked a specific question about whether there's any legal path. I mean, that's how that question starts. I'm just paraphrasing it, but I think I'm pretty close to it exactly. And the legal path is for Cal-Am to extract water for the proposed project. We are literally going to have to examine the physical and legal intersection of the ocean with the water found under the seafloor and the land and water found under the land, and what legal regimes apply to what. Now, you're right if you want to say, geez, Mr. Osias, couldn't you argue that? The answer is I could. But Mr. Owen, not a lawyer in the case, not a lawyer for any of the parties in the case, a law professor who's written extensively on groundwater, we think would provide helpful legal opinion, expert opinion, to be considered by you in your draft and by the state board in its ultimate answer. And I think I'm probably circling all the way back to the beginning, correct, in that we were somewhat intrigued by the court, including question 8.
Okay. So let me help out here. That's helpful background, and I appreciate that. I do see question 8 here. At least I have question 8 as I've written it in my hearing notice. I think that tracks pretty closely what the court put in its order. Let me just give the perspective here. Just because the court asked the water board a question does not necessarily mean it's a question of fact. I mean, the water board has both factual and legal expertise, at least I like to think the board does in its 25 100 members of staff and it's 5-member board. Even has 1 board member by law who has to be a lawyer with expertise in water right matters. So I think just because the court asked the water board a question doesn't make it a fact issue necessarily. It's an issue that the court wants the water board, as I read this, wants the water board to answer using the water board's expertise in water resource matters, which includes both expertise in complex technical issues and expertise in legal issues. So let me, we're not going to resolve this today, but let me say this. I think on one hand, I don't want to just cut you off, Mr. Osias, when you haven't had a chance to really develop an argument. And I did put you on the spot today, or Mr. Wilkins put you on the spot. But Mr. Wilkins may have a point here. So I'm going to do 2 things. First of all, you can file the written proposed testimony by July 1. And if I assume it would be MCWD wants to file a motion, whatever, I think I could normally done with a motion to strike and ask for to have that testimony not allowed. I mean, you can call it whatever you want. It could be motion in limine as far as I'm concerned. If it's a motion, I'll rule on it. And there is a government code section that allows me to rule on what evidence is allowed and not allowed. So if you want to file that, Mr. Osias, that written proposed testimony, you may. And Mr. Wilkins, you and your colleagues may file a motion objecting. Now, I did hear you say that you're concerned about having to develop rebuttal within 6 weeks. And I don't know whether I can rule on it that fast, but I will try. Let me just tell you, though, my preliminary ruling on this is testimony regarding legal issues, whether it's given by lawyers or experts, usually engineers with experience in water resources. I normally allow it if I think it has a bearing on findings of fact that I'm going to be including in a proposed order. And I normally do not allow it if I think it has a bearing solely on conclusions of law in the proposed order. And we usually do separate out at least somewhat in our, that's in proposed orders. Here we have a report of referee, but it's going to follow a similar format. So usually it's pretty clear. And then of course, you can make whatever legal arguments you think are appropriate in your briefs, and there will certainly be opportunity for that. And you can have Mr. Owen provide input on that. But I guess I'd say fundamentally, and I certainly have no question about Mr. Owen's expertise. What you say, he may be one of the finest experts on this field in the world. But at the end of the day, our conclusions of law are based on my staff's independent analysis of the legal precedents that you cite in your briefs and we apply to our findings of fact. So that's how we do conclusions of law. And I don't want to downplay it too much, but just because some professor thinks the law should be so-and-so doesn't really have a big bearing on how we develop our conclusions of law. You've all been lawyers for many years, some of you many more years than I have. You know how it works. Legal conclusions of law are based on legal arguments and whether they're persuasive or not. And they're persuasive based on the precedents that are cited and how the party argues those precedents should apply to a particular set of facts. So I think that's all I can say about this now. I don't want to say no, but I do want to give you sort of a preliminary indication, Mr. Osias, of where I'm coming from on that. But if you want to file that anyway, and you think it's appropriate, you can go ahead and file it by the deadline. Mr. Wilkins, I don't normally, I'm not sure that I want to specify a deadline for motions to strike, and let's call it a motion to strike. That's probably the best thing to call it. But I will say, if you want a prompt ruling, the sooner you file a motion, the more likely we're going to get a prompt ruling. I can't turn these motions around in a few days. It takes a few weeks. So that's probably the best I'm going to be able to do. I'm not going to change the deadline for submitting rebuttal testimony because we have a very clear pre-hearing schedule set out. And at the end of the day, if you think that's important and I haven't ruled, and you filed a motion to strike and I haven't ruled on it, all I can say is you may have to submit rebuttal testimony, or frankly, you may be able to respond to, if I allowed Mr. Owen to testify, you may be able to respond to that in your closing brief anyway, if it's really conclusions of law. So does that,
Mr. Lilly?
I'm sort of talking on the fly here, but I hope that provides some input. Mr. Markman, go ahead.
I just had one thought. I mean, we're sitting here and we have David Osias and Rob Donlin and who knows who else supporting CalAmp. That's plenty of legal expertise in the water rights field, as far as I'm concerned, as much as we care to fight with. But the way I look at it is, if somebody submits testimony on that question, it's just like telling them, you can write 2 briefs. You guys can write a brief, a trial brief or administrative hearing brief, opening and closing, and now you have a witness and you're throwing in a second brief by another professor or lawyer who reaches the same conclusions. I doubt they'll reach different conclusions with his own twist on it. And all of us could do that. We can line up, sure, we can go find somebody who's going to concur with us. I don't think it adds anything when we're briefing this anyway. It's not going to be testimony. It's going to be a supplemental trial brief. Now that's really all. That's how I foresee it. We're happy if they feel they're going to file it anyway. We're happy with what you said, Mr. Lilly, about a chance to move to strike it.
Okay, well then I'll stand by my process, and certainly you and Mr. Wilkins can, if they file it, maybe after what I've said, they'll decide not to, but if they do, and if you still think you need to file a motion to strike, then you can make those arguments in your motion papers. I guess it's going to be tight because we only have about 6 weeks here. And of course, I suspect if you file a motion to strike, CalAmp's going to want to file an opposition. So well, I'll tell you what, I'll do this that may help all of you. You may not think this is helpful, but you've heard Mr. Markman and Mr. Wilkins, you've heard Mr. Osias say what they plan to do. I think you could go ahead and file a motion in limine now, and then they can file, if they want to oppose it, they can file an opposition, and I can rule on it, and that will avoid this problem of you having, because I do appreciate what Mr. Wilkins said, the problem of having to line up an expert, hire an expert, get an expert's calendar open, and all that on short notice. So that might be a better way to go forward. Mr. Wilkins, your hand is up.
Yeah, and thank you, Mr. Lilly. We can certainly talk about doing that as an alternative, bringing something early. I guess one of our concerns was CalAmp's actual designation of experts in subject matter. You'll note that on the city and Marina coasts, we actually describe what the experts would testify on. And CalAmp just says for pretty much everyone, issues 1 through 7, and then for their legal expert, issue 8. So while we've heard what Mr. Osias said about his testimony, I think overall we are hoping that you would ask CalAmp to provide some type of supplemental disclosure about what these witnesses will be testifying as to. Specifically, Mr. Owen, we're kind of guessing what he would testify on, because it's a 2-part question on 8. And obviously the main issue I see it is, does the water board have an opinion? You're going to have a legal expert tell you whether the water board should have an opinion on these issues. So I do think it's likely inappropriate, and we can brief that, but I do think it would be helpful if we had some type of supplemental disclosure about the subject matter for Mr. Owen and their other witnesses for that matter. They've just listed 8 and basically given us no clue what they're going to be testifying as to.
So Mr. Moore, Mr. Osias, do you have a response to that?
Sure. And I wanted to start with that your comments are helpful. And
thank you.
And if I translated them correctly in my mind,
Attorneys, there's always a qualifier. I took the compliment, so now go
No,
with
it
the
is.
qualifier.
I'm
Go
going to
ahead.
repeat something that I think is a little shorter, but I want to make sure I got your point, which is if Mr. Owen was going to testify in what looks like purely questions of law that you would normally find in a brief, a la Mr. Markman's suggestion, and that would therefore only end up in a conclusions of law section, without pre-committing yourself, your sense is you find that to be unhelpful to the process and perhaps even inadmissible. If it sheds light on facts, you might land in a different spot. That's sort of what I heard you say,
Yeah.
and we take that to heart, and we'll act accordingly. We're at the front end of this process and think we should be able to, with that precaution very clearly stated in mind, go forward and see whether we submit something, and if we do, whether we're in one camp or the other as you compared them. Are we in the conclusions of law or the findings of fact or the mixed questions of law of fact where it helps with the facts? So that would be my first response. As to the add-on suggestion of Mr. Wilkins, let me just read you a quote from the detailed description next to one of the witnesses in the city's notice of intent. A full quote, a full range of hydrogeologic, groundwater, and related subjects posed by the 8 issues referred to the State Water Resources Control Board. I'm not sure that's different than issues 1 through 8, although it uses more words. So we have a very discrete, and the comments at the beginning of this is how did those questions get posed by the court? This is not a water rights hearing in the normal sense. This is a request by a judge for answers to 8 questions only. And one of the reasons Mr. Moore suggested a motion in limine, or maybe perhaps Mr. Wilkins suggested a motion to strike, is we see topics addressed in the proposed testimony that don't go to the 8 questions. And we would object vociferously to a referral moving beyond what the court asked, because we're not before the hearing office or the board for any purpose other than to answer the judge's questions. And the timing to do that is also relevant. And if we want us to do it after the testimony comes in, so we can point to why it's not one of the judge's questions, that might be easier. So we don't, I'm not raising a timing question per se, but that's one of the reasons those motions may be appropriate, not just who, but what.
Okay, well, I don't want to get into a lot of motions in limine before people have even submitted their written proposed testimony, because that we'd end up having to speculate about what people are going to testify to. And something else to keep in mind, there's no jury here. Relevance objections really matter a lot when you have a jury, because at least the theory is the jury can be persuaded in ways that are inappropriate, based on inflammatory stuff that's not really relevant and so forth. Where the theory is the judge, and I think by extension, a hearing officer, we're trained in the law, we're supposed to know how to filter out the irrelevant stuff when we're doing our decision making. So relevance objections, I'm not going to allow people to testify about anything. Stuff's clearly irrelevant. Obviously, I don't want to waste time on that, and nobody else does either. But I tend to be a little more lenient on that, because just because something comes in, if somebody objects on relevance, well, they can make that point in their closing brief, or I can ignore it when I'm preparing the proposed referee's report. So I don't really want to get bogged down with huge amounts of motions in limine on relevance grounds. even after
Right.
stuff is submitted, after stuff is.
So-
Proposed test, wait, let me finish.
I'm sorry.
After written proposed testimony and exhibits are submitted. I mean, people, obviously you can still object during the hearing. Mr. Lilly, I think paragraphs 15 through 17 of this witness's testimony are not relevant to any of the hearing issues. Therefore, I object. And if I agree, of course, the other side can respond. And then if I agree, we don't let those paragraphs in and they're formally not admitted into evidence. So we can do that during the hearing. So don't think you have to file motions in limine on everything. What I heard Mr. Wilkins say is he wants a ruling on this ahead of time, not for the reason of whether it comes in during the hearing, but so they can know whether or not to hire their own expert. And that seems like a whole different level. So with that, Mr. Osias, what have I said now that's prompted you to want to say something else?
Only that very point, which is right. I'll use as an example, but I don't want to debate the merits of it. Okay, but there is a topic called vernal pool management listed next to a witness. Okay, which is not a question the judge asked about. And so, do we hire a rebuttal witness? Because we didn't list on our list of witnesses anyone to talk about anything other than questions 1 through 7. So it is the same style of question, but we're not really sure what they mean by that. So we thought perhaps a motion after we saw it. But again, we would want to have that resolved fairly quickly. If it's not something the judge asked about, we could avoid having to put on a rebuttal witness.
That just
And
raises a
Mr.
question.
Lilly,
I was going to ask Ms. Meisenheimer, this came up. So what do you want to say about vernal pool management responsibilities for Lane Long?
from our perspective, it's very much within the scope of the questions that were referred. That I believe it's the 7th question that the judge referred. It goes to the impact of the project on Marina's primary and paramount water rights. And so what this talks about is the impact of the project on rights that Marina has to pre-existing water rights, beneficial uses. And so this is very much relevant to one of the questions that was submitted to the SWRCB.
Okay.
I don't believe Marina has.
Wait, okay. We're going to have time. Thank you, Ms. Meisenheimer. We're going to have time in October to argue this. I can guarantee you there is no way in the world I can rule on whether or not that evidence is relevant or not until I've seen it. And I've heard both sides, both attorneys' arguments about that. So you don't need to spend time arguing that point now. I got the question from Mr. Osias, the clarification from Ms. Meisenheimer. Again, that one we'll have to see at the time. There has to be some back and forth. That's why I have a round of rebuttal. I find it a lot easier to have people submit the written proposed rebuttal testimony ahead of time. The water board back in the old days, they would have all the written proposed direct testimony. They go through that and then they just start rebuttal and people would just start testifying. And for the reasons I said earlier, I think having the written proposed testimony ahead of time benefits me and all of you. So that's why I have the second round of written proposed testimony for rebuttal. But we're going to have to just see how this plays out. So let's do this. I will, in a pre-hearing conference order, I'm going to specify a deadline, which will be about 2 weeks from today, for Cal-Am to specify whether or not it still plans to call Mr. Owen as a witness, and if so, what topics it wants Mr. Owen it's going to ask Mr. Owen to testify about. And then I will give Marina Coast Water District approximately 2 weeks to file a motion to strike if they decide they want to. And then, and I'll just sort of see how this all plays out. And then I'll give about 2 weeks for Cal-Am to file a response. And then if I can, I'll try to get a ruling out. Hopefully I can get a ruling out before August 10th, I think is the deadline for rebuttal testimony. And I understand that may have some logistic issues if you have to, if Marina Coast has to hire a rebuttal expert. But I think based on what I've just said, that may not be necessary. And that's the best I can do. I want to allow due process to allow people opportunities to make these arguments and for responses before, so I can make a ruling on a motion based on some briefing. And I may shorten that first 2 weeks because presumably Cal-Am already has a pretty good idea of what they're going to have Mr. Owen testify to. Beyond that, I'm not going to ask for any more details on the subject of proposed testimony. It's just going to start. I mean, you're all such strong advocates. If I start allowing that, you're going to just start raising more questions. And I think the bottom line is we're better off to see what people file on July 1st, and we can go from there rather than spending a lot of time arguing about these notice of intent to appear forms. So I'm going to make a note on that so I can remember to do that. Designation, 2 weeks, motion to strike, and I'll give specific deadlines, 2 weeks. And I'm going to see how that plays out. I may tweak some of those dates depending on how that plays out. So does anybody have any further questions on that? Go ahead.
Mr. Lilly,
You were
go ahead,
asking
Mr.
us,
Moore.
Oh, wait. Ms. Meisenheimer, go ahead.
One clarifying question I had as we take a look at this and how the opening testimony and the rebuttal testimony are going to work. You've been very clear about the opening summaries really only being what's in that direct testimony that we submit on July 1. We also, of course, are going to have rebuttal testimony that comes in and raises issues and points. And so my question to you was, when, if there is an opportunity, is our witness supposed to respond to the rebuttal arguments? You know, is it something that happens, we wait and have cross-exam and then they get a redirect? Or is there an opportunity for them to include in their testimony a response to a rebuttal?
You're saying if there needs to be SIR rebuttal, basically.
Not so much in a formal SIR rebuttal. I mean, I've certainly seen that in cases where you do another round of testimony, but I've also seen it done where an expert will at times on the stand just address something that's in a rebuttal argument against their position.
Okay, so basically what you're saying is we have the first round of written proposed testimony, the second round of written proposed testimony, and then say your witness says, hey, I read a statement by witness X in the other party's written proposed rebuttal testimony, and I'd like to say something about that. And can I do that even though it's not within the scope of my written proposed rebuttal testimony because I didn't know until I read his? Is that what you're getting at? To paraphrase?
Yeah, I think so. I think it's particularly when a rebuttal witness has critiqued an expert, can they say something about that critique of their own report?
Yeah, along the lines of, he says, I don't know what I'm talking about, but I really do know what I'm talking about. I'm sorry if I'm trying to inject a little humor into this. I apologize. That's a very good question, and I don't mean to be glib. It's obviously a very important question. And I'm not sure how we should address that. And on one hand, I'll tell you my countervailing considerations. On one hand, I want to give people opportunities to respond to new arguments or new testimony that have been raised in rebuttal. On the other hand, I don't want this to just go on and on and on. I mean, you're all such strong and effective advocates. Everyone's going to want to have the last word. I just know how that works. So one possibility would be after the written proposed rebuttal testimony comes in for people to just file lists, which hopefully would be very short, along the lines of, I'd like my witness to be able to address these additional points that were raised in someone else's rebuttal testimony. You could just, point raised in other parties' rebuttal testimony. Here's the response my witness wants to be able to make. And we could have a deadline for doing that. That might be better. I don't really want to have another whole round of hearings. That can end up dragging on forever, not forever, but for a long time. So does anybody have any comments on that as a potential way to deal with this issue? And Ms. Meisenheimer has raised it. on behalf of her client, but obviously this could come up for any of your clients. Any comments on my proposal for how to deal with that? All right, let me see if I can put something in on that for, I'm just writing this down. Because it would be good if they could do that during the rebuttal phase of the hearing rather than have to go on. And hopefully at that point, we can close the loop here pretty quickly. And what another possibility is we may do that not as when they're summarizing their own rebuttal testimony, but we can just do it at the end of that phase of the hearing and just have a day or two where they do that, but without submitting more things in writing. That might work pretty well. It basically would be a rebuttal phase where written proposed testimony would not be required ahead of time, but it would be very limited to just rebuttal of specific points. So let me think about that and see if I can put something in the order that makes sense. I mean, I want to be fair, but I want to be efficient too. So I don't know, Mr. Osias, I think I may have cut you off. Did you have something else you wanted to say at this point?
I was just confirming you're going to send something out. We want to comply, obviously, and you're going to give us, it sounds like about 2 weeks to do something. And I just want to make sure we'll know specifically what you want us to do from your notice.
Yeah. I'm going to try to get it out today. I have a couple of meetings this afternoon, so either today or tomorrow, I'll try to get out a pre-hearing conference order that'll specify deadlines with some detail as to what needs to be done by each deadline.
Okay, that I was just trying to confirm that.
Yeah. No, these are all. This is why I have a pre-hearing conference. These are all good points, and I'm trying to address them as fairly as I can. All right. Anything else on process before we get into time limits and page limits?
Yes, Mr. Lilly, we have the deadline for all the written testimony is July 1st. We have a witness that has been in the hospital, an expert, and cannot complete all the work he needs to complete to provide that statement until July 15th. I'd like to have an extension of time from you, or we'll agree to anything else. If other parties want an extension to July 15th, we'll of course say, yes, that's fine with us. It does, I know, throw a little bit of a monkey wrench in the schedule and the deadlines. But I believe from what I understand of what he's gone through, he will not be able to get it done by July 1st.
And which witness is that, Mr. Moore?
It is Mr. Durbin.
Okay. All right. Well, I'm sorry to hear that. We have so many things to juggle here. I certainly hope Mr. Durbin recovers. That's obviously number one. I'll tell you what, I don't want to change the deadlines for everybody else. And I don't, because number one, I mean, that there's a roughly 6 week time frame in there between July 1 and August 10.
Right.
And that's going to be a very busy time for all of you. I mean, you have experts, hopefully it'll be the same people, and they all know the project and all that. They've all been working, I assume, for a while. So they're not starting from scratch, but that's still a fairly short time to prepare a rebuttal. So I don't want to shorten that gap. And I put August 10 in there because you all wanted to have time to take depositions, even though frankly, I'll say, I don't think you're going to need them, but that's your call. I'm not going to deny you the right to take them. I mean, you're going to have it all laid out in detail. I mean, the normal purpose of expert witness testimony, depositions, is to find out their opinions and the basis for their opinions. And you're going to have all that. But nevertheless, you asked for that time. So that's why I put August 10 in there, because then that gives the deposition time before the hearing starts. And so you can get the deposition transcripts and get ready for the hearing. So what I would propose is that for Mr. Durbin only, the deadline for his written proposed direct testimony and any associated exhibits be July 15. And then for any rebuttal that is just to Mr. Durbin's testimony, the other parties, presumably City of Marina and Marina Coast, would have 2 more weeks, which would be from August 10 to August 24 for rebuttal to Mr. Durbin. And if some of their witnesses are rebutting Mr. Durbin and other witnesses, they'll just have to prepare separate parts. Here's my rebuttal. I know it's a little awkward, but here's my rebuttal to all the other Cal-Am witnesses. That's due on August 10, and then rebuttal to Mr. Durbin due on August 24th. And then you'll have time to take Mr. Durbin's deposition if anybody wants to, and it won't disrupt our hearing schedule. Does that work for everybody?
Mr. Lilly, Kyle Brochard for Marina Coast, very much prefer to have all of the witness testimony submitted at the same time. If we're pushing back Mr. Durbin's by 2 weeks, then whoever is rebutting Mr. Durbin's testimony is doing so during the period of time where they're also going to be subject to their own depositions. And it's going to put a lot of pressure on everybody. We can push all of the deadlines back 2 weeks and still accomplish everything before the hearing dates. It'll be uncomfortable for us, but this timeline is probably going to be uncomfortable anyway. So that can happen, and I'd prefer that than us having experts and rebuttal experts who are trying to prepare rebuttal testimonies while also trying to prepare for depositions in the same week period.
Does anybody else have any comments on that?
Mr. Moore or Mr. Lilly, taking into consideration Mr. Brochard's comment, a proposed alternative schedule would be direct testimony July 15 for everybody. The rebuttal testimony gets bumped just 1 week, August 17 instead of August 10. And then similarly, depositions get bumped a week. Instead of August 17, we go August 24 to September 30-ish. But I think that accomplishes everybody's desire to get it done and what Mr. Brochard just said.
Yeah, I'm sorry, Mr. Lilly, that's actually cutting the amount of time we have for rebuttal testimony by a week. And I have no idea what their 9 witnesses are supposed to be testifying on right now. I mean, it looks to be that they're all duplicative. If they're all going to testify in issues 1 through 7, I don't know why we need 9 of them, but I guess I'll find that out when I get their written testimony. And no, I definitely do not want a shorter period of time to review all of that and prepare rebuttal.
That's fine. We can go 2
Would a
weeks
system-
to try to get it done for you. So if we want to push everything by 2 weeks, that's fine too. I was just trying to keep with getting everything done before the hearing date.
How long do you think you're all going to need for depositions? And I'm sorry, I shouldn't point to you, but do think about what I just said. I think it's an important point. I mean, I did this for over 30 years in your position. I never once took a deposition, and I never once went into a hearing and wished I had. I'll just say that, because the written proposed testimony gave me all the information I needed. And you're going to get rebuttal besides that. So again, you can do depots if you want to, but if we move the deadlines to July 15 and August 24, and then have the deposition period be a little shorter, it could be, just looking, instead of August 17, we could move the start of that 2 weeks to August 31 and have it go through September 30th. So basically we move everything by 2 weeks except the end of the depot deadline, which is moved by 1 week to September 30th. I think that may be, oh, Mr. Markman, I thought I had a solution. Now tell me what your
Well,
concern
you do.
is.
You're, Mr. Lilly, I've been thinking this over. I'm familiar with Mr. Durbin, pretty familiar with what he's going to deal with if he does testify. Hope he feels better. But I think the best answer was the first one that you had, which is extend him 2 weeks across the board and go with the rest of the schedule. I can't believe it's going to be so disruptive that we can't handle it. And I think anything else is going to be more disruptive, anything I've heard. So from my
Jim,
point of view,
we would be fine with that. The one caveat I would say is sometimes, and I'm not as familiar with Durbin's testimony as you are, but given that each of CalAm's experts are designated on topics 1 through 7, I'm anticipating there's going to be some overlap. And so we may have experts who are rebutting both Durbin and other people. It can be very hard to disentangle those rebuttals. So I just ask that if there are expert reports that are rebutting anything that has to do with Durbin, that those get kicked 2 weeks.
I think we have to, give something here because the man is ill. And I don't think, well, I'll be surprised if CalAm's team of lawyers offers technical testimony from Tim Durbin that's different from other people or concludes differently than they do, so as to disrupt our ability to prepare. It's possible, but I think it's probably pretty remotely possible. And if he's, I would think if we were in the same position with a witness who's ill, that we'd get the same accommodation. And I say disrupt the schedule as little as possible. So,
Okay.
back
Well,
to-
I didn't hear.
Mr. Lilly,
Oh, go ahead, Mr. Wilkins, go ahead.
on Mr. Markman's point, I think that, and I'm familiar with Mr. Durbin and have the same thoughts that I wish him well and a speedy recovery. If we had at least some minimal additional disclosures about the topics that CalAm witnesses were planning, so we weren't surprised. Maybe we don't think it's likely that Mr. Durbin will testify as to something that we haven't seen in prior reports that he's issued in this matter. But if we had something that just described briefly so we can gauge what all these 9 experts are going to testify as to, that would be rather helpful if we're going to extend the deadline. And with that, I think we could likely live with the extra 2 weeks for Mr. Durbin, just knowing that he wasn't going to have some big surprise for us coming up.
Okay, so here's what I'm going to do. I don't know what I feel like. I sort of feel like a first grade teacher having to break up a fight here, but I'm sorry if I know you're all trying to do your jobs and you're doing very well, but I didn't hear any reason why the deadline for any other witnesses' written proposed testimony should be extended past July 1st. So this, and I'll put this in the order. The deadline for July 1st for all parties to file written proposed direct testimony, associated exhibits, and exhibit indices is going to remain. The one exception will be Mr. Durbin and any additional exhibits that are associated only with his testimony and not with any other testimony will be July 15. And then the deadline for all parties to file written proposed rebuttal testimony will be August 17. I'm going to give you one more week. And for all the other witnesses, that's giving you an extra week from what you had before, which I'm sure you can take advantage of. Mr. Durbin, it means you'll have 1 week less turnaround time, but I think you will be able to deal with that. And then the deposition dates are going to be August 24. We'll delay that one starting by a week. So it'll be August 24, and I'm going to have that continue to be through September 23rd. That gives you a month to conduct those depots. And remember, you can start noticing those now, because I know a lot of times the trouble is not knowing, scheduling it. So, and that, I did say that at the last pre-hearing conference, but let me emphasize that as well. You don't have to wait until July 1. You've got the names of them all. You can schedule them all now. Pick up the phone and talk to each other. I'm sorry if I'm starting to sound preachy here, but please, you're all good attorneys. You know how to work things out if you need to. So go ahead and set up your deposition schedule now. And believe me, I know if somebody ends up you decide you don't want to take a depo or someone doesn't submit written proposed testimony, you can take them off schedule and nobody's going to complain about that. So go ahead and do that now. I'll tell you what, I'm going to give you till September 30th, just because there are a lot of witnesses and that's going to be a pretty intensive time for deposition. But please schedule them now. Set them now. You know what I'm saying. Work now to set the dates for within that time frame so they're on everyone's calendar, including the expert witnesses, because what I really don't want is for somebody to come in and say, I wasn't able to finish the depo by September 30th. I want to move the hearing date. I do not want to move the hearing begins. So, Mr. Donlin, your hand is up. Please go ahead.
Thank you, Mr. Lilly. Not to take us backwards, and I appreciate your efforts to work through complicated scheduling issues, but the point that Ms. Meisenheimer raised is a good one. Not only will the Marina parties have to deal with potentially overlapping testimony submitted on multiple timelines, but Mr. Durbin's testimony will likely affect the testimony of others of Cal-Am's witnesses, which could raise complications about the completeness of the testimony that they are able to submit on July 1st. I appreciate, again, your efforts to work through these complicated issues, but I think the proposal from Mr. Burchard and Ms. Meisenheimer, where all, at least expert testimony, technical testimony is submitted at the same time, rebuttal testimony to all of that technical testimony at the same time, will minimize the work that this group will have to do with respect to analysis of those various testimonies, and hopefully make it easier for all of us. Again, appreciate the difficulty of this issue, but Ms. Meisenheimer's point is well taken by us, and we may have the same issue that she addressed in preparing our expert testimony that would be submitted on July 1st if we go with a bifurcated schedule.
Okay, does anybody have any response to that comment from Mr. Donlin? I'm not sure. I mean, I think getting, I guess Mr. Donlin is, I just really am wondering, is that really true that the other witnesses other Cal-Am witnesses need to see Mr. Durbin's testimony before they complete their own testimony?
I believe so. I think Mr. Markman's point, Mr. Durbin was part of a team of experts that were compiled during the permitting process, otherwise known as the Hydrologic Working Group. Mr. Leffler, Mr. Yee, Mr. Feeney, the various experts on our witness list were part of that team, and their work was done collaboratively. And Mr. Durbin's work will inform the expert work of others. So although they may not see anything entirely new, we don't know exactly at this point because Mr. Durbin's health issues have prevented him from collaborating exactly how that overlap will occur.
Okay, well, I am concerned that if I made it July 15 for direct for everyone and rebuttals due on August 17, that cuts out a week for the other parties to prepare their rebuttal, which I think is going to be an intense process. I mean, does anybody for Marina Coast or City of Marina want to comment on that? You're the ones who are probably most affected by this.
Speaking for the City of Marina, we would strongly prefer to go with the proposal that you just made, Mr. Lilly, of most reports coming out on July 1 with only the necessary ones delayed to July 15, and then the week longer reply period so that it's a week more for others, a week less for Durbin. I think that allows more time for depositions. I know I have a 3-week jury trial in September, so the farther we push, it gets harder for depositions. So that would be our preference.
Yeah, Mr. Don, I mean, I'm trying to juggle a lot of different things here, and I think I'm going to leave it July 1 for everybody except Mr. Durbin and July 15 for Mr. Durbin. And if you think, and not you, but you and your team and your team of attorneys and your team of witnesses think that somebody needs to revise his or her testimony that's been submitted on July 1 after seeing Mr. Durbin's testimony. And I'll allow you to do that by July 15, of course, showing the revision. So I think that's the best way to address, and we have a lot of countervailing concerns here. But I think that's the best way to address that. The point you have raised, and also to address the point Ms. Meisenheimer has raised. And then it'll all be in. I mean, most of it will be on July 1. I don't imagine there'll be huge revisions, but that way, Marina Coast and City of Marina can start preparing their witnesses, preparing rebuttal. And of course, Cal-Am can start preparing rebuttal to the City of Marina and Marina Coast witnesses as well. I just think having that time there is going to be important. I'm just very concerned. Otherwise, somebody's going to come forward around July 16th and say, we need more time. And that's going to end up potentially disrupting the hearing schedule. I mean, this is all sort of predicated on wanting to get the hearing going on October 19. So let's plan to do it that way. I know it's not exactly what any of you want, but I think that's probably the best way to address that. All right. Oh, Mr. Osias, I thought I was going to be able to move on. What else do you have?
No, I'm not going to address the schedule again. I just wanted to say, and I know it's going to be in the recording of this, but for privacy reasons, Mr. Durbin had preferred to not have his name mentioned. And so at least in your issued order, et cetera, I'm not sure whether you can address that or not, but he was concerned that people would know that it was him. And so I'm just alerting you to that.
Okay, all I was going to say is the deadline for Mr. Durbin's written proposed testimony is July 15. Is that going to be a problem?
No, I don't think so.
Okay, I won't say why.
Yeah, that's that. Thank you very much.
All right, and thank you for letting me know, because probably otherwise I would have said why, because I thought it would have supported your request. But if you don't want me to say why, I won't.
Right, I'd request the others not to make that public too. Thank you.
And just, I assume nobody has any objection to that. I mean, we certainly want to respect that privacy issue. All right, thank you. You know, we're all professionals. We all need to work together in this business. All right, thank you. So with that, we're going to move on. As far as, there are a couple of points that were addressed in the pre-hearing conference statement from City of Marina and Marina Coast that I want to discuss. Hearing briefs and opening statements. I do agree preparing and filing hearing briefs is a very good idea. And I was going to propose that the submission deadline be 1 week before the hearing begins, and 20 pages be sufficient for those briefs. Again, and have the brief separately address each hearing issue. I mean, it's not a closing brief. You don't need the same level of detail in your legal arguments, but that will help me and my staff read things ahead of time, and really it will help us focus on the hearing issues. So I think that's a good idea. With that, I don't really want 45-minute opening statements. I mean, you probably have picked up on this already. I can process written materials a lot better than I can process oral materials. I think probably all of you are the same way, because if I see something and then I'd read another sentence and then I want to go back, I can go back. I can go at whatever pace I want. Where if I'm getting a delivery, obviously I can't do that. I mean, I can ask people, I can interrupt and all that, but it's just not nearly as effective of a mode of transmitting information. So I'm planning to have opening statements be limited to 20 minutes and just be summaries of the hearing briefs. And all you really need to, at that point, it's Mr. Lee, I'd really like to emphasize these 4 points from my hearing brief. You don't need to go through every single issue and all that again. Trust me, if you file it, I'll read it. So that's my plan on that. As far as summary slides, I will go along with that. We do this in some hearings when people ask for it. It just makes for some confusion, but I understand you're going to work very hard to get all the written proposed testimony for both direct and rebuttal in. And I'd rather you have a little more time to hone and refine your summary slides, which aren't going to be as necessary for people to prepare a rebuttal. They won't need the time. So I'm proposing that those deadlines be 3 weeks after the deadlines for the written testimony for you to submit summary slides. But the summary slides really do have to just be summaries, not any new materials. So any comments on either of those two items before I move forward? All right. As
Sorry,
far
one
as
question, Mr. Lilly.
Go ahead.
You mentioned the deadline 3 weeks after the deadline for written testimony. We would propose that the deadline be, because we have our deadline for opening case in chief testimony and for rebuttal. So we propose that the deadline for all be 3 weeks after the end of rebuttal testimony. Is that what you had in mind?
It's not, you mean for all slides?
Yeah, for the summary slides, it would be great if they could all go in 3 weeks after the deadline for the rebuttal testimony.
Okay, this is a little bit confusing, and maybe I wasn't clear, because my plan is everybody puts on their cases in chief where their witnesses summarize their written proposed testimony for their direct testimony, all 4 parties, cross-examination, admit those exhibits, and then we probably take a break of a day or so, and then we start rebuttal, and we go through the same order, and the parties all have their witnesses submit their rebuttal. So there'd be different slides for each witness, at least the ones that have both direct testimony and rebuttal testimony. There'd be a different set of slides for each witness's summary of each of those testimonies. So that's why I had thought that there would be different deadlines for those, because I don't see why the summary slides for your direct testimony would need to be delayed until after you've prepared your rebuttal testimony. So am I missing your point here, or does that explanation help?
That explanation helps. It struck us that there may be some benefit. We're going to do our case in chief. We'll submit that testimony. And then we're going to see rebuttal testimony, which is going to see the areas in which the other side is challenging our witness. And so we thought there might be some benefit to putting together the summary of the presentation once we understand what the points of contention are going to be. And so the desire was to put the case in chief summaries after the deadline for the rebuttal testimony.
So there'd still be separate slide summaries, but you just want a later deadline.
That's correct.
Okay, does anyone else have any comments on that? I do see some merit to that.
We don't, Your Honor. Or Mr. Lilly, excuse me.
Okay. All right. Well, that one I'm okay with. So basically, then the deadline for all summary slides to be filed would be, if we have August 17th for the rebuttal, it'd be whatever 3 weeks after August 17th is. Is that? I think that's what you're proposing, Ms. Meisenheimer. Is that right?
Correct. Thank you.
I'll have to get my calendar out. I'm just going to write 3, and I'll, obviously this well, right? I'll in order. So 3 weeks after August 7th. All right. Thank you. As far as the time summaries for direct testimony, I read the pre-hearing conference statement from Marina Coast and City of Marina. I'm going to wait to decide about that until after I see the written proposed testimony, both direct and rebuttal, and the slides. And then I'll decide. I'll just say, again, you're maybe picking up on this. I'm going to read it all. And the purpose of the summary is, not hey, but Mr. Lilly, here are the 4 points I'd like to emphasize in my testimony. It's not to go through the whole thing again. So, and with slides, you can do that. And it's sort of like 1 minute per slide and you can go through. I mean, you're all used to being in court where you're subject to time limits. And here we have all the written testimony submitted in advance and the slides submitted in advance. So I'm going to hold that for consideration until after I've seen the slides and the written testimony. But be warned, I'm going to limit the summary time. And I'll just tell some of you, I'm sure, are used. I'll get to you in just a minute, Mr. Wilkins. Some of you, I'm sure, have practiced before the Public Utilities Commission, and I just checked with a friend I have who just became a hearing officer there, and he confirmed to me what my understanding was of their practice. They don't allow direct witnesses to summarize their direct testimony at all. It's Mr. Witness, did you take the oath? Yes. Is Exhibit A your testimony? Yes. Start cross-examination. The Water Board has never gone that far, although sometimes I've been tempted to. So that is sort of where I'm coming from, rather than the court model where you have a jury and you have to go into a lot of detail to make sure it's all out there in public. So that's why the summary time is normally fairly short. So with that, Mr. Wilkins, go ahead.
Thank you. No, maybe I'll hold this question, but my only concern was if we don't know the time limits, preparing the summary slides could be, it would be helpful to know the time limits before we prepare the summary slides was my only point. But I guess we can just skip over slides if we don't have enough time. So we could probably work with that. It would be ideal to know that, though.
I'm not going to put it in the order, but I will tell you all so you have it. It's a good point. My plan is maximum of 15 minutes per witness for summary. So, and I know from when I used to give presentations, I still do give presentations, you sort of can think about 1 minute per slide if you don't talk too much about each slide. So kind of keep that in mind. If there's some reason for more than 15 minutes per witness, then we'll talk about that. And I don't know whether, I think that sort of ends up being about fair between Cal-Am's witnesses and at least the numbers for Marina Coast and City of Marina, maybe not quite, but let's see where we are. I mean, there are a lot of witnesses here. That's still a lot of summary time, and I may shorten it down more, and we may have to skip over slides. But Mr. Wilkins, I hope that helps a little bit, but that's sort of my plan. I seriously doubt it'll be more than 15 minutes per witness for summaries. That's what summaries are. All right, cross-examination is another important point. Obviously, you can't do cross-examination before the hearing, but I just will say, in my experience, a lot of cross-examination in water right hearings has been very inefficient. A lot of this is when we have unrepresented parties who don't have any legal training trying to do cross-examination. It really is very hard. Cross-examination is an art. But it takes a lot more time than is necessary. So, as I said earlier, when you're conducting cross-examination, I think by far the most effective way is to ask my staff to display the witness's written proposed testimony, go to a certain paragraph, certain lines, have you read it yourself. Mr. Witness, did your testimony state on lines 15 through 17, it is my opinion that X because of Y? Do you see that? Yes. And then ask a question about that and have them explain or clarify or whatever. I mean, I know we've all been trained as lawyers, never ask witnesses questions on cross-examination where you don't know the answer and try to force them to make certain answers. I'll just tell you, my experience is that just does not work at all in water right hearings. So collectively, we probably have about 300 years of legal experience here on the screen. And I know you may not agree with me on that, but please consider that. Cross-examination for water board water right hearings, it's going to be most effective if you just limit it to asking witnesses to explain things that are unclear in their testimony, presenting them with other documents if you think there are things you want to impeach them about, or ask them to respond to another witness's testimony if you think there's a discrepancy that they can explain about them. And I want to get to the truth here. It doesn't really help to try to trip people up or force them to say things that they're not going to say. it just ends up eating a lot of time. It's very inefficient. So anyway, and also, if you take these witnesses' depositions, that will allow you to focus even more. And if necessary, obviously, you can use the deposition transcript to impeach the witness if a witness deviates from his or her deposition testimony. So I'm not going to set time limits now, but I'll just say, really think about focusing this. I mean, I've got technical people, I have technical training. We're going to get to the technical stuff. So you don't need to try to, I'll just say, trip people up or force them to say things they're not going to say. That just eats a lot of time. Okay, a couple of any questions on that? That's sort of preachy on my point, and I apologize, but it could end up saving us all a lot of time and frustration. It's going to all come out. At the end of the hearing, we're going to know the parties' positions, their witnesses' positions, the basis for their opinions, their opinions and their basis for their opinions. And then you're going to be able to make your legal arguments, and then we'll sort through it and prepare our proposed referees report. And of course, the board will consider that. So just want to emphasize where we are, give it a little perspective. A couple of other points. Other public records, the pre-hearing conference statement asked about whether parties can reach or how to handle other public records. I really recommend that you all confer as necessary regarding other public records. I mean, there shouldn't be much dispute about the authenticity of other records. I cannot imagine anyone here is going to try to fabricate a document. I mean, none of you would do that, and you wouldn't get away with it anyway. So if you can reach stipulations regarding authenticity of documents, you won't need to subpoena the custodians of records. I think potentially you may want to I think somebody listed a custodian of water board records. And if we need to, if you can subpoena that person may be able to do that. Although frankly, you can probably stipulate to the authenticity of water records anyway. If you stipulate to authenticity, you can still make arguments regarding relevance, and you can still make arguments regarding hearsay. I just will call your attention to Government Code 11513 subdivision D, which discusses how the water board treats. It's in the Administrative Procedures Act, but it applies to the water board hearing. So that discusses how the water board will treat hearsay. So I think you can all save yourselves and me a lot of time if you can reach stipulations regarding authenticity and just preserve, to the extent you need to, objections regarding relevance or hearsay. That should make things go a lot more quickly. Any questions on that? I'll pause for a moment here. I'm not going to set deadlines, but try to get that done before you submit exhibits. And if you can't do it by then, at least before the hearing, and write it all that out. I mean, I'm really prevailing on you to use all your experience. You know how to meet and confer and reach agreements on procedural issues that you can agree to that don't jeopardize your client's interests. So, Mr. Wilkins, what's your question now?
So it's a little bit different, but it deals with exhibits, and it deals with one of the, on page 15 of your order, it talks about parties' exhibits based on models or technical studies.
Oh, yes.
In this matter, we have a fair amount of modeling that's been done, and we have what's called AEM technology that's at issue. And these are what I'll call voluminous files. And I guess my question is, you said that the party should submit sufficient information so a qualified independent expert could reproduce the model. And so I guess the underlying question I have is, if our expert is relying on modeling, did their own modeling, whatever it might be, are you saying that you want us to submit the data that or the model? I mean, some of these are like things that would take a significant amount of time to download, and I just wanted to get some clarification on that issue, if you could.
Okay, Mr. Osias, your hand is up. Does your question concern this issue or something else?
It was very simple. The hearing notice had a June 1 deadline for stipulations. You've just suggested, which I agree with, that we should be working, et cetera. If we reach stipulations after June 1, I assume there's stipulations, you're not going to have a timeliness concern.
Yeah, that's correct. I was trying to prod the parties along, but if you need more time because of these exhibit things, and this may bear on what Mr. Wilkins just asked about as well. So, I mean, I'll take stipulations anytime, but it's in your interest to get them done as soon as you can.
Okay.
So I'll make a note of that. Thank you. So Mr. Wilkins, you raise a very important question. And let me just tell you, I wrote that part of the hearing notice. It's a little different than how the Water Board has done this before. And this is based on my experience, and I've been through this a fair number of times. There are two countervailing considerations here in my mind that I was trying to work a fine line or a line between. Number one is, I mean, I know how complicated models are and model files and so forth. And to some extent, if somebody just testifies, I'm a really good modeler, I've done this a long time, here's my black box, I put in this input, here's my result that comes out of the black box. And the other party then says, well, I don't agree with what's in the black box. That's the fundamental problem we have here. So I don't necessarily think that somebody has to produce so much information that somebody else could rerun the same model, but that's why I use the reproducibility standard, because I think that level of detail of going into what we'll call the black box of the modeling is necessary so that the experts' modeling assumptions can be tested. Now, but on the other hand, I'm very concerned about what you just said, Mr. Wilkins. I don't really want the record filled up with gigabytes and gigabytes of data files that, frankly, we have no way of using. The other parties' experts may be able to use them, but I mean, we're not capable of rerunning complex technical models, even if we have the data files. So those are my concerns. Before I turn it over to anyone else, Mr. Wilkins, do you want to say anything else about this and how you might propose that we address this? I'll just say one possibility is the parties can exchange data files among themselves and they don't need to come into the record, which might work. But do you have any other suggestions here before I ask others?
I think that might be the best solution, Mr. Lilly, is that if the parties are relying on it and each party will provide it to the other side upon request. I just wanted to make sure what we had to submit to the Water Board, but it sounds like what you want to make sure is that the parties can access whatever files experts are relying on, so that if they want to run it, they can. And that seems to be the intent of what you're doing, not to have us submit this all to the Water Board. I think that works, but open to other suggestions too.
Okay. Yeah, well, that's why I was trying to explain what I said there. And maybe I didn't. I mean, this is probably the most model intensive. I'm sure it's the most model intensive matter I've handled as a hearing officer. So we're having to break a little bit of new ground here. Does anyone else have any comments on that? All right. I don't see any other hands up. So I will make a note to modify that provision of the hearing notice, basically along the lines of the witnesses shall describe the basis for their modeling or other technical work. I'll try to figure out in some level of detail. I mean, I think the concept that an independent expert could reproduce the results is important, but as far as making data, voluminous data files available, that's just on request of other parties, that do not need to be filed with the our office and added to the record. Okay, good point. Anybody else, anything else on that? Thank you. So, and of course, stipulations are in order here wherever possible. It ends up making all of your lives a lot smoother. Mine also, but yours more. So please try to work those things out. The next question was designation of the hearing team. I'll see what I can do about this. Let me just tell you, the problem we have is we have our initial hearing team, but then when we get to the board process, the board, we are not attorneys to the board. The board is not my client. I'm an attorney. By law, I have to be an attorney, but I don't represent the board. So the board is represented by the Office of Chief Counsel. So when they get to their process, obviously they have to pull in attorneys from the Office of Chief Counsel, and sometimes they want to pull in technical experts from Division of Water Rights. We do have one technical expert from the Division of Water Rights who's been assigned to help us, a groundwater expert, and I will list her name in our in the pre-hearing conference order, so you know that. But beyond that, we don't have others right now, but there may be others down the road. So I'll do the best I can on that. It's a fair question to know who's on the board hearing team, but there's just a limitation to how much I can answer that at this point. I mean, obviously, at the end of the process, the board members will be involved. All right. AHO staff exhibits. At this point, I don't think there's anything more than what we've already posted on the record. But if any of you think other exhibits are relevant, probably the easiest way is to submit them as your own exhibits. But if you think there's general background documents that should come in, please let me know. I think there were a couple listed. One exception to that. The pre-hearing conference statement states that there were, on page 4 of the pre-hearing conference statement, starting at line 13, Marina and MCD requests, there are 3 documents listed there that they be added to the basically historical documents and documents from court files. One is the Brochard Declaration in support of MCWD's opposition to referral motion. And I thought we had all the papers regarding the referral motion. So we should add that. Final environmental impact report for the Monterey Peninsula Water Supply Project. I think that's an appropriate historical document. Again, I don't know whether it'll come into evidence, but we can put it in our record as a background document. And then a January 31, 2019 PUC order modifying the decision D 18-09-017. So does anybody have any comments? I think it's best for us just to put those into the record so we have them. It just makes it easier. And then if there are any evidentiary issues, we can handle that later. Can somebody from Marina Coast provide those to us? I assume, Mr.
Yes,
Mr. Brochard.
yes, we can do that.
Okay, so why don't you upload those? We have activated the upload folders for the parties to file their exhibits. So when you can upload those, they're going to be too big to email, I'm pretty sure. So upload those to your MCWD's upload folder. And after you have done that, send an email to the AHO with CCs to everyone on the service list advising us that you have done that. And then we will move them over to our administrative record folders, and we will send an email to everyone advising them that we have done that. What's a reasonable time frame, Mr. Brochard? Can you do that within a week, do you think?
Yes.
Okay, thank you. We have a lot to cover. I appreciate all your patience here. Okay, depositions. There was a request that I imposed time limits on depositions and also provide for parties to pay the expert witness fees, the way it's done in court proceedings. I will tell you, I think I have the authority as part of my general conduct of the hearing to impose time limits on depositions that are related to the hearing. I think I have that authority, just as my general authority to run the hearing. I do not think I have any authority to order parties to pay expert witness fees. I mean, obviously there are provisions in the Code of Civil Procedure regarding the court for doing that, but I just don't think I have any authority to do that. I mean, if there were a dispute, I don't know what I'd do. I don't know that I could order somebody to pay those fees, and I certainly wouldn't want to take it to the board. They wouldn't know what to do with that, and I don't think the board has any authority to do that. So let me split that up into two parts. First of all, there was a proposal that depositions be limited to 7 hours per expert witness from Marina Coast and City of Marina. Does anyone from Cal-Am want to respond to that?
No, Ms. Lilly, that's fine.
Okay. I mean, that should be plenty of time when you have the written testimony in advance. So I can do that, 7 hours. As far as the expert witness fees, I mean, the normal process when you're doing expert witness depots in a civil proceeding is the parties work out a process for paying those expert fees. And of course, it's all governed by, I think it's in the Code of Civil Procedure 2034 series. As far as I'm concerned, the parties should try to work that out. You can decide whether you want to pay each other back and forth for expert fees or whether it's going to even out. And if you have any disputes that you can't work out, I think you can file a motion with the court. I hate to lateral this back to the judge, but I think the judge has authority to enter an order on this where I don't. So that's my thought on expert witness fees. Does anyone have any comments on that?
No.
Okay. And I think that's what I said in the notice, so we'll leave that as it's there. I mean, obviously, if you can work things out, I'm sure the judge would appreciate it. But I'm going to put resolve or file motion with court. Okay, site visit. Bear with me. I think I'm almost to the end of my list here. Even though the hearing issues primarily concern things that are underground, I still think a site visit would be helpful for me and my staff. It just really helps me to be able to visualize to the extent I can where things are, even if I have to try to then imagine where things are underground. I would like the parties to meet and confer and develop a proposed site visit itinerary and schedule. I would think we could do this all in one day. I don't think there's a lot of driving. I think everything's more or less in the same area, but you may tell me otherwise. I'd like to do that site visit after the parties have presented their cases in chief and before rebuttal starts. That way, I at least have some idea of what the issues are, probably a very good idea. And then also, if I have follow-up questions, when we're back on the record in the rebuttal proceeding, I can ask them. We normally bring a camera to do recording of video plus audio, and then we take pictures. But I don't really want to have a lot of detailed questioning in the field because it's a horrible way to try to make a record, particularly if it's windy, and getting everybody gathered around and so forth. So I usually limit the questions in the field to, hey, what's that building? What's that shed over there? What's inside that? And so forth. Just describing what we see out there. And then if there are follow-up questions regarding the technical issues, we can do those when we're back on the record in the hearing. So I mean, logistically, this isn't too bad. We can probably drive from Sacramento to the area of the site the night before and then be ready to spend the day touring the site. And if necessary, we can stay over or we can go home when we're done. But since we don't have to make airline reservations, it'll be simpler. Some of you may have to, but we don't have to. So does anybody have any comments on site visit? That's certainly my plan. Mr. Wilkins, your hand is up. Go ahead.
A question on the date. So if I heard you correctly, you wanted to do the site visit after direct testimony, but before rebuttal testimony starts. So you're looking at sometime in that late October timeframe we should be looking at to try and schedule this. Is that correct?
Yeah, and then you'll have to tell me, I could assume most of you, I think, are Northern California. So is anybody going to have to fly for the site visit, or is Mr. Osias and Ms. Horning? Okay. So, I mean,
We're down here.
Mr. Markman.
Yeah, we're down here in Orange County, so one of us will probably fly up.
Okay, and you don't need to all go.
No.
As long as at least each party has at least one attorney, it's going to be fine. Trust me. The only reason I ask is what I'd like to do is just wait and see where we are in the hearing schedule. And then, when we know, okay, we're going to finish the hearing on Friday, let's plan to do the site visit on Monday or Tuesday. We can just set the date kind of later. I mean, yeah, we do have to make reservations, but hopefully that time of year we can make them if we need to. So, I mean, I understand with this many people, it'd be good to have some advance planning for that. So I'll put in the order for you to all try to work that out. And maybe we can pick a date in the hearing schedule, maybe 1 or 2 days, and just sort of in the middle and plan to do the site visit there. But it'd probably be better to have some advance decision on that. I like the idea of going on the fly, but I can see where that doesn't work that well for everybody.
Mr. Lilly, you may want to ask Pacific RMC's counsel since CEMEX will have to allow us onto the site, whether there is any type of advance, or maybe he can just tell us when we meet and confirm. I just want to, it won't be something that we control, Marina or Marina Coast.
Okay, Mr. Newdecker, Mr. Wilkins makes a good point, and obviously we don't want to do anything that would put anybody in any jeopardy from a safety point of view. Do you have any comments on that?
Yeah, I mean, I haven't discussed this issue with my client, but I will. And, we'll figure it out during the meet and confer process. I'm sure we can.
Okay, good. Thank you.
And good. Mr. Lilly, if I may, Ruth Stoner-Muzine from Marina Coast. To the extent that you would like, and I would encourage you to visit our clients' well sites, we can make arrangements for that as well.
That's the Marina Coast well sites?
Correct.
Absolutely. Yeah, I mean, that seems like that is definitely relevant to the hearing issues. So, yes. Okay. So, I'm going to try to get out the pre-hearing conference order as soon as I can. Try to do it this week if I possibly can. And we've talked about all the deadlines, so you know what they are, and then we'll go forward. So, I'm beginning to think it might be good just to set a date for another pre-hearing conference in October, sometime around the before the hearing. I might move the date for the hearing briefs to be 2 weeks before the start of the hearing, and then have another pre-hearing conference 1 week before the hearing day. I just think we might have things we want to talk about, and obviously I want to have all of us in the room, virtual room, when we talk. So, Mr. Moore, go ahead.
Yes, we talked earlier about motions to limit, motions to strike, whatever we want to call them. And I would like to ask you to set a date that we can file motions. The reason being, I think there's some issues that we will address in those motions that will have a major impact on what evidence comes in and what evidence is offered, and who can testify and who can't testify. It begins with the fact that the city does not have any water right.
Okay, yeah, you don't need to get into legal arguments.
Well, okay, I just want to make, you said, but there are very important issues. I'll leave it at that I think will have a major impact on the hearing. So I'd like to have the opportunity that we could brief a couple of these issues in advance of the hearing. I know it's a tight schedule at this point. I know it may be difficult, but these are big issues.
Okay, well, That's very important, and I agree. I will set a schedule for that. And obviously, if we can limit the hearing and avoid extraneous evidence, that's important.
Absolutely. We're not going to, there's nothing, and I apologize for raising the issue. But I think this hearing will be important. I think, and it could change the nature of the case, I believe.
Well, okay, so for motions in opposition, and that might be something we could discuss during the next pre-hearing conference as well. So thank you for reminding me about that. That's important. Again, I have no idea how I'll rule on them, no idea what they're going to be or who will file them. But yeah, no, I understand. But let's set some dates for those if people want to file them. Obviously, then that will be after the written proposed testimony, written proposed rebuttal testimony are submitted. Then motions in limine or motions to strike could make sense. Mr. Wilkins, go ahead.
Just one question, and I apologize if I missed this somewhere. Will the actual hearing itself be hybrid? Or will it all be virtual or all in person? I don't know that you said that before, and if I missed it, I apologize.
It's in the hearing notice. It's all virtual.
It's all virtual at the hearing. Okay, I missed that.
Yeah, and the reason is, I mean, I don't know what the Cal EPA building rules are going to be. It's very hard to get hearing rooms, and this format seems to work pretty well. So unless, I mean, I assume most of you would probably prefer this than having to travel to Sacramento. So that's my plan, is for this to be all virtual. We'll get to see each other in person during the site visit, but otherwise it'll be virtual. So, okay. Let me just check my notes here. I think I'm almost to the end. I am to the end. Does anybody else, Mr. Wilkins, you can take your hand down unless you have another question. Your electronic hand. Okay. All right. Does anybody else or anybody have anything else that you want to talk about today? All right. I think I've worn you all out. So thank you all very much for your attention. This is very productive, very helpful for me. I will get the order out, and you all have a lot of work to do. We will be getting a lot of filings, but unless something comes up, we're not going to be meeting again until probably approximately 1 week before the hearing. Around October 12th, we will be meeting again. So thank you all. Have a good week and enjoy all your pre-hearing preparations, and I will talk to you then. Goodbye.
Goodbye.
Thank you, Mr. Lilly.